So good afternoon, everyone. My name is Sarah Morris, and I am a Fourth Circuit representative on the Florida Bar Young Lawyers Division Board of Governors. As a government attorney, I am very excited to welcome you all to today's webinar, What's New with Public Service Loan Forgiveness and How to Get Your Loans Forgiven. Today, we are very lucky to have Christie Arkovich, who will be speaking to us about the Public Service Loan Forgiveness Program, or as we're going to refer to it, the PSLF program. Christie has been a Florida licensed attorney for more than 25 years after having graduated from Stetson College of Law with honors. She is a frequent speaker at various consumer-oriented continuing legal education seminars. Christie has spoken to other attorneys at the American Bankruptcy Institute, the Tampa Bay Bankruptcy Bar Association, and the National Association of Consumer Advocates. Christie writes a quarterly column for the Tampa Bay Bankruptcy Bar Association called the Student Loan Sidebar about recent student loan related laws, regulations, and developments nationwide. Whenever possible, Christie shares her knowledge about student loans that she has gained from working as trial counsel for Sallie Mae, ECMC, and other student loan servicers and guarantors, as well as her experience in her current law practice. I want to thank you so much on behalf of the YLD and all of our listeners for being here with us today, Christie. And just so everyone knows, Christie is going to be taking questions at the end of the webinar. So please feel free to put your questions in the chat and we will go through those and we will be asking Christie as many as we can get through at the end of this webinar. So I'm going to go ahead and turn it over to Christie so she can give us as much as she can in the remaining time. So thank you again, Christie, for being here.
Absolutely. I hope that the information today will be helpful for everyone. Let me go ahead and share my screen here. All right, we will hit play. There we go. All right, hopefully everyone can see my screen. I'm in Tampa, Florida, and I have done a lot of student loan work over the last few years. I'm also a member of the committee that helped establish a new student loan management program in our bankruptcy court, which covers the entire Middle District, so from Jacksonville on down to Fort Myers. And that's one of the nice things is that we've enabled someone through bankruptcy to take advantage of many of the federal loan programs that previously they couldn't. It was just stuck in the federal forbearance, and that was that. So I do want to remind everyone that that program does exist, and there is one in the Southern District of Florida too. If you have anyone that's filing bankruptcy, you might want to think about utilizing some of the federal programs that were never able to be utilized before. So today's presentation, I wanted to focus on the public service loan forgiveness. There is a waiver program, very limited, only for 1 year, but we're calling it the FSA or FSLF fix because it's designed to fix a number of the problems that we've seen throughout the past several years. This is a little history of myself. I've been practicing for over 25 years in Florida. Primarily in the last few years has been student loan work. And so I don't want to spend a lot of time on why we got here, but I did want to identify quickly what some of the problems are with the Public Service Loan Forgiveness Program. First of all, the servicers, they don't represent the borrowers. They represent the other side, the creditors. And in part, that may be part of the reason for the extremely poor communication that everyone has had with respect to their federal student loans. And that ranged from how to get on the correct plan, what loans qualify, to if it should change servicers, you name it, it existed. It was a big problem. And so back in 2000, and I think it was 15 or so, we identified there was a huge problem with the older FFEL loans. Now, these are federal family education loans. Before the direct program basically took over and the FFEL program was discontinued, that was in 2010, 80% of the federal loans out there were the older FFEL loans. So that means if you went to school before 2010, you probably had this loan type. And unfortunately, that loan type was not eligible for public service loan forgiveness when that program was passed in October 2007. But the communication to the borrowers that they needed to change this older loan type to a newer direct loan didn't happen for whatever reason. And so one of our initial clients that I always like to use as an example, he was a weather person with the National Weather Service. He served his 10 years. He applied for discharge. He had done a consolidation, but unfortunately he did a FFEL consolidation instead of a direct consolidation, didn't count. So what did that mean for him? He had to start all over again. His entire 10-year history that he had spent paying back his loans made him, those payments were ineligible, and he had to start his 10 years all over again. This client had to move from Key West, Florida to Kansas in order to drop his living expenses so he could afford his loans. Now he's back with us. We're going to basically make sure he gets it now. He should have no problems now. So the old FEL loans were probably the biggest reason for someone not getting the discharge as anticipated. A second problem, which was almost as big as the first one, was the servicers would give someone a lower payment, but it still wasn't based on their income. It wasn't something they had to certify every year. Instead, it was basically something that was lower, and it was often a graduated, extended graduated, or there's an just a regular fixed extended program. Those traditionally didn't count for public service. So they're on the wrong payment plan. Sometimes the wrong payment amount. We did see some clients who, what they would do is they would round up, or they would, basically they would round up. And so they would go ahead and pay a little extra, but then sometimes they would just pay incorrectly, and they were off by even pennies. And then they also were paid a little bit late. There was the paid ahead status problem, where if you paid your loan in advance, then technically there wasn't a loan payment due the following month, which meant that that month didn't get credit for public service loan forgiveness. There was also lost records, there were servicing errors, and most importantly, there was just huge delays on everything. People were waiting years to see if their employment counted, if their payments counted, and they just gave up hope. And so that has been what we faced. There's been a number of governmental investigations as to that, and it's a long-term problem, and it's something that we attempted to fix with a couple class actions, mixed results on that, but one still, I think they're both resolved now. But this fix, I think, will do a huge amount to fix all these problems. And so how did Ed do this? First of all, they didn't require an act of Congress. There wasn't a student loan bill. We've had the infrastructure bill, we've had the just all kinds of reconciliation bills and things like that. And student loans, while initially it was talked about a lot in last year's election, since then, it sort of has been continuing to be moved down within Congress. But at the same time, the Department of Ed has undertaken their responsibility and role to see what problems they could fix internally without having Congress, or even a bipartisan Congress, try to enact something. And so they use what is called their emergency powers to, for public service, create a 1-year waiver. And so basically, if your payments haven't counted previously, they're probably going to count now, as long as you know what to do and you do the correct thing. Most importantly, if you have the older loan types, and that might be a FEL loan, a Perkins loan, anything that's not called direct, you can have a direct subsidized and direct unsubsidized. They're both direct loans, but anything else that's a federal loan needs to be consolidated. There was some immediate confusion whether it needed to be done before the end of the month last month, or a couple months ago, October 31, 2021. But it's 2022. So you have 1 year going forward to do this. I would encourage you to do it early, though. I mean, why wait? If you wait, you're going to forget. Things are going to happen. We're all attorneys. We're all busy. It's never going to happen. So go ahead and consolidate your loans early if you can. Now, I just want to cover a couple quick things about consolidation, because I won't get into this in great detail later. Never consolidate a Parent Plus loan with your own loans. If you don't know why, reach out to us. It's very devastating. It can be devastating to the amount of payments that you have to make. The second thing is when you consolidate to a direct loan, typically what would happen under the old system is that you would lose all of your payments that you made under your FEL loans, and you'd have basically the payment count would restart. That doesn't happen here. For this limited purpose, for this waiver, you get to count all the payments that you made previously on a FEL loan, as well as any payments on the new direct loans. But you have to consolidate by October 31 of 2022. It's 1 year only, then it reverts back to the old system. A lot of folks wonder, well, why are we going back to the old system? Why don't we make this a permanent fix? The belief is that the only way the Ed could do this was they limited to the 1 year provision. To do more, it has to be an act of Congress, and we don't really want to wait for them. And so what are the rules? Well, first of all, you have to be employed with a public service entity. There's no way around that. And there is a help tool that I'll show you later in the presentation about how to find out whether your nonprofit is qualified, for instance, but any full-time employment, and that's defined as 30 hours or more. It can be two separate jobs, by the way. It can be combined, but 30 hours or more or full-time for a local, state, or federal government, or a qualifying 501c3. And there is a certification form that you can have your employer fill out. Section 3, it asks a few questions about exempt status, full-time employment, and then it has primary purposes of business. If it's religious, there's a qualification in there that your time can't be, it can be doing some things for a religious entity, but not other things. So it's specifically in the form. And so you fill in that form, you send it in. Typically within about 30 days, you'll get a response back indicating whether your employment is qualified and so forth. But there is a help tool that I'll get into a little bit later about that. But you not only have to be employed full-time by this government entity or a qualified nonprofit, you also have to consolidate, like I mentioned, before the end of the October next year. And what's designed to do is make sure that any payments that were wrong, the wrong amount, they were late, they're on the wrong payment plan, they're on the wrong loan even, any of it will count. But here's the kicker. You have to have made a payment of some kind. Forbearance and deferment and loans that are in default should not count. There may be some limited exceptions. We have one client, for instance, they had a loan from a family member and they paid in lump sum for a period of years. We're going to try to see if that will count. There may be folks who were pushed into forbearance, even though they were chronically underemployed, to which they could never maintain a minimum standard of living, plus make a payment on their student loans. They should have been an income driven all along, but instead they were pushed in forbearance because that was an easier solution, I think, for the lender to do at that time, or the servicer, I'm sorry. They're not supposed to count, but maybe there'll be some limited exceptions where forbearance and deferment might count. But typically you have to have made a payment for it to count. The other good thing about this program is that you don't still have to be employed by the qualifying entity. Under the regular rules, you have to not only be employed by the qualifying entity at the time that you submit your application, but you have to stay there until they give you an answer. And so there were folks who were overshooting their 120 payments because they still had to be there since the servicer was so far behind in processing their application. That is waived during this 1 year. And think about it, it makes sense. People who are going to apply for this waiver are people perhaps that used to work public service and maybe they no longer do so. But if they can go back and get 8 years of credit, it might be worth doing another 2 years public service somewhere. It doesn't have to be consecutive, doesn't have to be with the same entity. And now all of a sudden they'll get public service forgiveness in 10 years, which is tax-free, versus maybe the 18 years they still have left on a 20 or 25-year plan. So there will be people who are no longer working public service that can go back and try to fix what happened and try to get credit for that time. I anticipate a great number of those. So how to qualify? Full-time employment. And I know I'm repeating a couple of these things, but I want to kind of drill it in over and over again. Full-time employment. You have to have made payments during that full-time employment. You want to consolidate any other federal loans, FEL or Perkins, into a direct loan. Now, if you've never submitted a public service loan certification form that basically identifies what your employment is, or if there was missing documentation for periods of time that you did submit, then you're going to need to submit a new form or submit one to begin with. And think of it this way. They're not going to know that you're in the program. They're not going to know that you're even working public service. They don't have a connection directly with the IRS to know that you're working public service. So you have to tell them. How you tell them is you submit this certification form. It's available on the studentaid.gov site / public service loan forgiveness, PSLF. But you need to submit that to let them know that you're working public service and so forth. If you don't, they'll never know, they'll never process you. And again, you have to make some payment of some kind to count, and forbearance and default typically won't qualify. Some things are automatic. If you have submitted an application for discharge, you don't have to do it all over again. They will automatically re-review that. But as any attorney, if you're not sure, if you don't have proof of receipt, why not send it again? What's the harm? I mean, they'll get more than they need. That might overwork them, but you'll be protected. So if you're unsure of anything, then it can't hurt. I mean, there's no fee, there's no problem, there's no fine, there's no problem with sending in an application again. And you'd want to identify who you worked for, what the starting and ending dates were, things like that in order to get credit, and they'll count up that 120 days or 120 payments. Some things are automatic with respect to military service members and federal employees. They do not have to do anything. What they're going to do is match the Social Security numbers for federal employees and military service. But that means that anyone who's employed by a state or local or just, some other nonprofit, that's not going to happen automatically. So again, you have to fill out the certification form, identify who your employer is if you have never done so before. And if you don't have records of having done so, do it again. So to summarize, you've got 1 year. This should count all payments, kind of give you a second chance to try to get credit for those payments. A lot of folks have asked, well, if I consolidate now, won't I lose credit? No, those pre-payments, pre-FEL payments that you made before consolidation will count. There's automatic credit for certain folks, military and federal. And if you've previously been denied, it should be re-reviewed. But if you're unsure, file an app. There will be some servicer changes. Fed Loan handles all the public service loan forgiveness servicing. And a few months ago, they announced that as of December 14, they were going to discontinue servicing. That caused a lot of consternation because they handle the entire public service program. And folks were worried about their records being lost and things like that. And so they have agreed now to extend their contract for an additional year. What servicing changes we expect to occur, and we're starting to see, is the non-public service loan forgiveness are going to Nelnet. So if you're working public service and you see your loans all of a sudden are sent to Nelnet, then you might want to be aware there could be a problem. They may not believe that you're in public service. So you'll want to contact your servicer. You'll want to fill out the certification form, make sure you get into public service then. The public service clients are supposed to go to Mohila, and that's good news because Mohila shares the same software platform. So that will cause a lot less servicing transfer problems, paperwork problems, counting of the 120 payments. Hopefully things will go smoother than what some anticipate because the same software is being used. Don't worry if the transfer doesn't occur immediately. They are doing them in waves. It's going to take a little bit of time. They are happening automatically. There's nothing you have to do to effectuate that change. Currently, the certification form has not been redone. It is to go to Fed Loan at some point, and it says to the address on the bottom to go to Fed Loan. At some point, that will be revised and will be put up on the studentaid.gov site. So just keep an eye out on that. And there are some resources available to you. The studentaid.gov has a specific site on public service loan forgiveness waiver. I like to get my information from the Department of Ed's press releases. We have clients that will reach out to us nearly immediately when they hear something on the news. And unfortunately, the way we deal with captioning and titling of things, it's incomplete. And so I had a client a few weeks ago that contacted me as soon as she heard the first news story. She read a couple, 3 other news stories. They all had the same or similar title. And she was a teacher or something like that, I forget. And she was convinced that, no, she was a nurse, I'm sorry. She was convinced that she would be eligible for public service loan forgiveness. But unfortunately, she was counting time that didn't count. And there's going to be a slide here a little bit later about what's not counted. Well, what's not counted is payments that were made before October of 2007. The reason for that is because that's when public service loan forgiveness was enacted by Congress. So there's no program that pre-existed that date. So this client had been working public service since 1998 or so. And so when she counted her 10 years, she included that time period that she would not be eligible. It took me a while to convince her of that because of the headings that she would just read off of Google and so forth. So I think one of the best places for information is press releases because it's a lot more accurate than what you just might read on the news or so. The help tool that is now available on studentaid.gov/public service loan forgiveness. It is an online tool that is designed to get you into the system faster. So this is particularly for folks who are currently not in public service. Maybe they had worked public service since 2007, but now they're private, or now they're private. They've heard about this. They want to get credit for that earlier time. Maybe it was a full 10 years and their entire loan will be forgiven now tax-free. But this help tool is online. You need to know 3 things before you get on: your employer identification number for your prior employment, start and end dates also. That will get you into the system faster, but by no means are you not required to still file the hard application. You have to mail in the public service loan certification form. It has to be filled out, signed. Your employer has a section to fill out. You still have to send that in. That is manual. That's not an automatic online type thing. You don't have to use the help tool, but it does, I understand, get you into the system faster. They like that. It's also a way for you to maybe more quickly identify if your employer is eligible. What I usually will do is I will tell my client, like we had one this week that is looking for a job at Goodwill. And so Goodwill is a 501c3, but they have different primary purposes of business that might be listed there. And I wasn't sure of all the things that they did. So I asked my client to go ahead and take the certification form to the payroll or HR department, have them fill that out or tell them how they would fill it out so that they would know, is this job that I'm asking for, is this going to be covered by public service loan forgiveness? Because if not, I might want to go to a different entity to get that protection or go private and make more money. So likewise, you can use this tool to anticipate that as well. The certification form comes back in about 30 days if they remain on target. The tool, I haven't used it myself, but it's probably somewhat instantaneous because it links to the EIN number and so forth with the tax return. Now, some folks, when they were signing up for this presentation, asked, well, going forward, what do I need to do? If I was on a extended program or a graduated program, and now those payments will count, can I still stay on the same program? No, you have to go on income driven going forward. So when the forbearance ends, which is scheduled to end in January 31, we were told in September that this would be the final extension. That was virus mutations and such, so we're not sure if it will be extended again. We don't have any indication that it will. It probably will not. So be prepared in February to make a payment. Be prepared to try to figure out what you want to do between now and February, because us student loan attorneys, there's not that many of us, number one. And number two, we're probably going to be very busy in February. So don't wait till the last minute. You may not even be able to get an appointment. We do one-on-one consultations to go over what someone should do specifically for their income, for their marital status, and things like that. But you need to go in an income-driven plan. You can't stay in the older, extended, or graduated plan, even though they may count now. So what income-driven plan do you want to go in? For purposes of today, to leave time for questions, I won't spend a lot of time in identifying all the nuances between the plans. There's 8 or 9 different ones. Invariably, we will find someone in the wrong plan. It's very common that someone will be put in, ICR or something like that, and they will never change. Each one of these plans were passed by Congress particular years. The first one was ISR. It has no forgiveness at all. The second one, IBR, was passed in 2009, and then there's been extensions of that, the IBR for new borrowers. There's been pay and repay and ICR and such. Each one is a little different. Each one was designed to correct a previous problem. So the rules of thumb I like to use is this, and this is just a quick overview. If you don't understand any of this, then you might want to talk with a student loan attorney or try to research more on your own as to what you should do. But just remember, if you're on repay, which is a 10% program, it's one of the last plans that was passed. It's basically calculated at 10% of your discretionary earnings. It counts both tax returns. And so if you are married and your spouse makes the same or more than you, that's going to really raise your payment quite a bit. And so the way around that is you might be eligible for pay, which is pay as you earn as opposed to revised pay as you earn. But pay is disqualifying for some loan years. I won't go into the specific details here, but not everyone's eligible for pay, where most everyone is eligible for repay. So, but pay has that advantage of not only being a little bit less time, it's 5 years less for grad loans, it's 20 years, but it also lets you file a separate tax return. If you happen to have a loan type that you're not eligible for pay, then you might want to switch out entirely of that and go into IBR, which is income-based repayment. It's one of the more popular programs. It was one of the first ones, the first one that had forgiveness. So we see a lot of folks in it. how it lets you file a separate tax return. If you're not, if you're married, you can file a separate tax return. What you'd want to do is compare what your tax hit would be from filing separately with your accountant or tax advisor to what your savings would be on your student loan if you filed separately. For instance, you may have someone that if they're married and now they file separately, they might have a $2,500 increase in their taxes. But if they can save more than that annually on their student loan, then they might want to go ahead and do it anyway. And so you have to actually run it through TurboTax or whichever tax advisor you use to determine what your actual tax rate would be so that you can see whether it makes sense for you. But we use IBR for a lot of people who want to exclude their spouse's income, alternatively pay. We use repay for someone who is single almost always because it's the lowest possible payment. Each one of them, the period of time for forgiveness is between 20 and 25 years. There's some nuances in there. There is a program called ICR. It is what I call inferior. It is not as good of a program in that it has a higher payment. It's 20% of discretionary earnings. It's also using a lower poverty standard for expenses. So it comes up usually a few $100s higher. We generally won't use ICR for anyone except if you have Parent Plus loans. So remember earlier when I mentioned that if you have a Parent Plus loan, you want to keep it separate from your own loans. That's important. If you do one of these consolidations to take advantage of public service, you need to make sure to keep any Parent Plus loans separate because it will make all of your loans only eligible for ICR going forward, and that will probably increase your payment plan by a few $100s. So Parent Plus loans are a very different breed in and of themselves. Try to keep them separate as much as you can. And if you're in ISR, by all means, you need to immediately get out of that. That has no forgiveness. You probably need to reach out to someone to see what can be done about that to try to get credit towards forgiveness from prior years and such. But the thing I wanted to mention about today is that you need to restart your loans coming in February. You need to go on an income-driven plan. I would not rely on the servicer to pick the plan for you. So in the form, there's a specific thing that says, would you like us to enroll you in IBR, all these other programs? And then there's one that asks, would you like us to decide which one for you? Don't do that. You don't know what algorithm or what training that person is getting that does that for you. You don't know what information they're looking at. I'm hesitant. I want to make my own decisions. I want to have my own plan. I want to know why I'm doing it. And so do that and make sure you know what plan you're in, why you're in it, what advantages and disadvantages it has. And when you do so, you'll know exactly what it means when you're going to get forgiveness, and you'll know exactly when that forgiveness will occur. And most people don't know that. You're miles ahead if you do. There is some additional information available. There's a calculator. It's called a loan simulator or repayment calculator. It's on studentloans.gov or studentaid.gov. I use it myself. The difference is that I will know what loan changes I can make to get a better response. The program doesn't really know that. The program will identify what loans you have and what IDR programs are available. It won't extrapolate from that, maybe what you could do to make it better. So just know that. We do offer updates. And so I try to do about 5-minute updates on YouTube on a student loan sidebar YouTube series that I've started in the past year. Kind of follows along with a column that I write for the Cram Down, which is our local bankruptcy publication for bankruptcy attorneys and judges and so forth. And it's just talking about student loans. The videos are really addressing things that we see coming out of the Department of Ed or Congress about changes that are occurring. And so what I try to do is identify what the change is, who it's to affect, and what you need to do to get it. I think it's important to do that because with student loans in particular, it's not transparent. The system is far more complicated than it ever should have been. It shouldn't be that hard to repay a debt, but it is. I mean, I have attorneys that see me every day and they have no idea what to do with their student loans. I have people with PhDs, same thing. These are very intelligent people in their own areas, but the curtain is closed and they just don't know what to do with student loans. So I like the YouTube series because it's not a lot of reading. It's just 5-minute videos and we try to cut to the chase. And it's, I think, more accurate than what you might read in the news or by clicking on some kind of clickbait that talks about forgiveness. And certainly don't I would not just rely upon your servicer for information. And I would definitely not rely on someone that calls you out of the blue. There is a lot of folks that call saying that they're Sally Mae, saying that they're Navient. They may only be scams, and they may only be trying to get your personal information. Mostly, usually, the servicers, if they want to contact you, they're not going to do so by phone. They may if you're in collections, but for the most part, they're going to communicate with you by letter or through their online portal or website. They're not just going to pick up the phone and call you. So most of those are scams. My mother-in-law, I like to tell this story, during this past year, she's 80 some years old. I don't even think she had a student loan, but yet she gets regular calls about her student loan. So why are they wasting time doing that? Well, maybe she'll bother to tell them what her social security number is or something else, or maybe she'll start making payments to them. And so if 1 out of 3 people have student loans, there's a lot of money to be had there. So make sure that you are not dealing with someone who is some kind of scam, and phone calls is particularly egregious for that. The Department of Ed also has an Ombudsman office. I've left the phone number there. If you Google Ombudsman, it'll also come up with their email and fax and mailing address and such. What I like to do is I consider them as sort of an appeal department for the Department of Ed. If I have a client with a complicated issue, it's usually involving accounting and forensic type stuff. I will suggest that they outline as much as they can remember and as much as documentation as they have to show the Ombudsman office what the problem is and ask for it to be fixed. The Ombudsman office has access to most of your information as opposed to a servicer that may only have the years that you had the servicer for the loans. And they can usually piece together things. They're usually staffed with higher trained individuals. And so you can usually get to the bottom of things inexpensively, because that's a free process, through an inquiry into the Ombudsman office. The CFPB, Consumer Financial Protection Bureau, it used to be a good resource for us. During the Trump administration, unfortunately, it was really not. Perhaps it may take the reins again one day and be a source of information and things like that. But in the meantime, Ombudsman office is good for any special inquiries. So I did want to cover areas that this fix did not help. Parent Plus loans, there is some talk. I haven't quite figured out the answer for this as to whether Parent Plus loans will be covered by public service loan forgiveness. There's some varying information on that. So you might want to just continue to watch our blog, which is on our website at ChristieArkovich.com, or our YouTube channel, see if we have any updates on that. It's a little bit unclear as to whether and how Parent Plus loans will be given public service loan forgiveness. Initially, the reports were that they were not going to be included at all. Now it looks like they may be included, but there may be something special to do. Another thing that's not helped is the joint spousal consolidation loans. I don't know if those of you knew this, but there once was a program that when you graduated, you can consolidate your loans with your spouse. And that was a horrible, horrible program. And so it was shut down, but there are problems where people are still in the program and they can't get out. I spoke with a person yesterday, in fact, and they can no longer consolidate to a direct loan because they're in this program that was dismantled and they're not allowed to consolidate out. And so they're not allowed to get public service even under the fix, because the fix requires them for their payments on their older FFEL loans, for them to count, they now have to consolidate before October 22 or October 31 of 2022. So there's no fix for that. And so right now, there's not a lot of folks in that. So I think the Department of Ed has been focused on the primary areas where they have hundreds of thousands of borrowers they can help at once. And this is a little bit lower down that totem pole. We have a couple clients in this boat though, and we're likely going to file what's called an adversary process in bankruptcy to have our judicial branch tell the executive branch, hey, here's what you need to do. I believe they're allowed to do that. So we'll see. But that area, those with joint spousal consolidation loans, are not benefited by this public service loan forgiveness fix. The overhaul is continuing. They are continuing to do different things with public service to help individuals. We're not sure exactly what to expect. They are doing rulemaking committee meetings. They're on their 3rd week right now. And so the overhaul is continuing. So stay in touch. There's going to be continued things. I mentioned that no payments counted prior to October 2007. The reason for that deadline is because that's when the public service loan forgiveness program was put into place. And initially it was only for direct loans. That's why we have this problem where the FFEL loans initially weren't counted. Now they're going to be counted for 1 year. There still is no partial loan forgiveness. I'm a huge advocate of, I would love to see 10% per year, 10,000 per year, something like that, where someone can work public service for 3 years, get 3 years credit, get experience, get contacts, and then go out and work privately, rather than spending a whole 10 years with a government entity to where maybe they can't go private at that point. However, that doesn't exist. I'd like to see that in the future, but right now it's not, it's all or nothing. So 120 payments, full forgiveness, tax-free. Anything less than that is the equivalent of nothing, no forgiveness. I mean, you still would get credit for the 20 or 25-year plan, whatever income-driven plan you're on, but you wouldn't get the public service taking that down to 10 years. And then there is no countdown process for non-public service loan forgiveness clients. So let's say that you're, a few years into public service, you decide that you don't want to finish out your 10 years. You're okay with that because you have your own firm, or you're working somewhere, you're very happy, a private employer. You still want to have a countdown, right? You're on a 20 or 25-year term instead of 10, but you still want to know when that ends. There's no countdown process. And the reason for that is because it's not a priority for the Department of Ed. They have so much that they're working on. The earliest date that I believe that they could have forgiveness would be 2031. So closer to that time period, they probably will have some kind of form that will allow people to figure out how many months count, because currently there's no way to do that. You can go into your National Student Loan Database, your NSLDS report is supposed to be in there. That report, though, I have to forewarn you, it's usually 30 or 40 pages of text. It's very, very hard to read. But it may have in there somewhere if you can figure out and count how many payments you have. The documentation that you should keep for public service or for any countdown for the non-public service plans as well is records of your payments, records of your tax returns. I mean, I know the IRS will have them for certain years going back, but you might want to just keep a copy too. And that way you'll be able to see where you are. So what can we expect next? Well, right now, Ed is holding its 3rd week of negotiated rulemaking. And these committees is where all these changes are coming out. There's going to be more changes to the total and permanent disability program. They're going to more than likely drop the income monitoring for the 3-year period after someone is declared disabled. There's some additional changes for that. There's changes to interest capitalization that was being talked about yesterday. That wouldn't be in effect until July of 2023. Since it was just yesterday, I haven't reviewed what it's going to be, and it hasn't been passed yet, so I don't know exactly what it will be. There'll be changes on the closed school discharges, probably an extension of the time period for someone to file. Fault certification, that would be where someone did not have a GED or a high school diploma. There's a new IDR program or plan being discussed. It's not been passed yet. That's why I don't want to talk about it today, because it's not been passed, but it is going to be for those lower income individuals. So I would like everyone to make a note to check our YouTube channel, maybe every couple of weeks going forward, and subscribe if you can. We will have at least 1, if not 2 videos on the new IDR plan as soon as we know what it has. Basically, it's got some levels with respect to what your payment would be or not be for certain levels of income. And it's hugely important. I think that most people public service are probably going to be eligible for that plan or very close to it. So definitely stay in tune, because that's something you probably want to apply for. Even if you're in an income-driven plan now, doesn't mean you can't switch. You still retain your credit. You can go from IBR to pay or repay to ICR to this new one. You can do whatever you need to do. You don't lose your credit. And the capitalization changes may help it where interest is not capitalized when you go from plan to plan. If you get forgiveness of the balance, you may not matter. But if you're not going to get forgiveness, we typically don't want a lot of interest capitalization. So we can get into that more if we need to. So all of these things they're talking about, there's no consensus reached on exactly what's going to occur in these areas, but we do expect significant changes to all of these programs in the way that each one of them are probably going to be easier to apply for, or the relief is going to be broadened in some fashion. And when I say easier to apply for, some will be automatic. Like one of the changes recently to the total and permanent disability program is anyone who was qualified for Social Security disability would automatically get approval for discharge of their federal student loans, because it's kind of hard to get the Social Security disability. And it would just be a Social Security matching in order to do that. And I think there was a news story out that 323,000 borrowers, 100,000 borrowers would be impacted by that. So those are changes that we've seen with the disability program. It still means that anyone who doesn't have Social Security disability would still need to file an application for TPD though. But they're trying to make it easier. They're trying to match Social Security numbers when they can, particularly for federal and military where they have the ability to do that. They're trying to broaden out relief. They're trying to fix the problems that we've had, those problems being public service, which is what this fix is for. One of the significant things they've been doing is redoing the rules for the fraudulent schools, the borrower defense to repayment. Those have changed significantly. We are now filing those applications again. And that's what if you went to one of those, it's usually a for-profit school like Corinthian and Everest and IDT and ITT and things like that. There is some resources also that we have on our website, which is ChristieArkovich.com. If anyone would like a one-on-one consultation, we do that. You could email us at info@ChristieArkovich.com or reach out to our phone number there. I did want to leave plenty of time for questions. It looks like we have about 15 minutes left. I haven't been monitoring, but if you can identify any questions for me, let's go with that portion.
Absolutely. Thank you so much for all of that information. So we have been going through the questions, and I'm just going to start with the questions that I think seem to be reoccurring. So let's begin with, when should we rectify employment and income for repayment? Should we do this now or after February?
Usually it depends on what your income is and was before COVID. If your last tax return that you filed was lower, then I would like for you to certify earlier so that you can use that tax return as opposed to recertify your income after you file next year's return. You can also wait to file next year's return, not file it in January or February when you usually do, but file it maybe in April or even later with an extension and such. So file early if you want to take advantage of lower income, or wait until you're told that it's time to recertify if you are making more money now.
Okay, awesome. How are they taking into consideration the loan waiver due to the pandemic? The loan payments were suspended for a year. Does that time still count?
For public service, it does, which is the only time that usually forbearance will ever count in your favor towards public service loan forgiveness. But it did count, even though you weren't required to recertify, because recertification requirements were waived during COVID. It does count for public service.
Does every loan have to be consolidated for public service loan forgiveness? If the borrower only has direct loans, subsidized and unsubsidized from law school, do those have to be consolidated? Essentially, what loans need to be consolidated under this waiver? We have a lot of questions about that.
Okay. If you already have a direct loan, you do not need to consolidate. Your loans are already eligible for public service loan forgiveness. You do, however, want to file an employer certification form, because you need them to know that you're working public service. You need to make sure you're working for a qualified entity and that you're working enough hours. Plus, you need to make sure you're on an income-driven plan going forward. Now, if you haven't been in the past and you've had a direct loan, if you're making any payment, this waiver should allow for you to get credit for those payments. But you don't have to consolidate an existing direct loan.
Should we reconsolidate loan directly with the Department of Education or with our loan servicers?
Either way, I don't know if there's a real advantage. Typically, when we've done consolidations, we've wanted to deal with whoever we thought would give the best answers to our clients going forward, or whichever one was the easiest process, whichever one wasn't overwhelmed at the time. It's changed. We're also expecting a number of student loan servicer changes in the future. So even though you may pick a particular, you go on the Department of Ed's website or your own servicer's website, and you pick a different entity to consolidate with, it may not stay with that. Just like a mortgage, it can be transferred to another party. So I don't know if it really matters so much. I don't think I have a personal preference right now. if that matters.
Let's see. We have a lot of questions about so if you worked for a qualifying employer for 10 years, but you never signed up for PSLF, and on the 30-year repayment plan, will the loans be forgiven under the waiver if you never did it initially?
Yes. As long as you made some kind of payment, even though it was the extended graduated 30-year thing, your payments will count if you now consolidate to a direct loan. Does it say whether they have FFEL or direct loans on that question?
It doesn't.
Okay, so if you have a FFEL loan, you need to consolidate before October of next year to get credit for this. If you have direct loans, then just file the application identifying the starting and ending date and the employer, and then the hard copy of the application has to be actually signed and filled out by your employer. But you will get credit for those years, and you should have a discharge as soon as they're able to process it.
Great.
Yeah, exactly.
Yeah. Does 1099 employee count as full-time if it's over 30 hours?
Well, a 1099 employee, a 1099 is not an employee. That's an independent contractor. I do believe you have to be a wage earner, a W-2 employee in order to get credit for this. I have not heard of any independent contractors being considered under this, but I actually haven't had any reason to research that. So I'm not sure if there's any provisions of the waiver that would apply. We might want to look further at that question. They're not supposed to count under the traditional program.
Okay. What documents do you recommend saving before new service provider takes over?
Well, I particularly just want to save records of payments, payment history. That's the biggest thing. And then you should keep copies of your certification forms. I recommend that you file them annually. It's not required, but if you do so, FedLoan would have been keeping track of where you worked each year and giving you credit for those time periods. So I think it's good to pull and keep copies of your applications. But Mohila is supposed to be overtaking the servicing within the next year from FedLoan, and they do share the same software platform. So all the information from one should ideally transfer to the other fairly easily.
Which is great, because I feel like I'm just now, after 7 years of practicing law and working with this program, I'm just now getting a handle on it. So I'm glad to hear that they're probably going to have the same software.
I was too, because it could have been a real mess.
What constitutes a, quote, significant income increase to be considered a substantial change to income where you need to rectify?
I don't know the answer to that question. I would have to look into that further. Yeah, I don't know the answer off the top of my head.
Okay. How long will the forgiveness process take once all the documents have been submitted?
Well, we don't actually know. In the past, it's been significant and it's been on hold, in part because of changes with FedLoan. Going forward, things will smooth out, but it's probably going to take a bit of time. So I really have no way of knowing how long it would be. One of the nice things is that under this waiver program, if it occurs within this year while the waiver program is in effect, someone doesn't have to remain employed. I've always, during the traditional public service loan forgiveness advice I give clients, is I would always tell them the program requires you to still be employed at the qualifying employer when you submit your application, and then you have to still be there when it's approved. So you can't make 120 payments and then decide to go work privately, telling a private employer, I'm almost done, I'm ready to go, and you have to still be there. That's being waived, but only during this waiver period. It should go back into effect after October 31. So if your application hasn't been reviewed by the end of October, I would want to still stay employed by that qualifying entity, because the traditional program will kick back in, and that is a requirement of that program. The nice thing is that if you do make overpayments, I believe they are supposed to give you a refund. I am not quite clear if that's a refund on only direct loans or a refund on loans that were made on FFEL loans. I believe it may only be those on direct loans. And when you think about it, the Department of Ed can give money back, right? Because a direct loan is something that it owns. Whereas a FFEL loan is originated and often owned by a third party, a commercial lender. And so the Department of Ed can't give someone else's money back. And so it makes sense that they can't give relief for refunds on FFEL loans, but they probably can on direct. I'm not 100% sure on that. And that could change in the future, but I think it might be limited to refunds for those that are overpaid on a direct loan.
Do you know when Fed loan or another servicer will count the time during the pandemic?
When they will count the time during the pandemic. I don't know if I understand that question. During the pandemic, everything has kind of been put on hold. They have been processing claims under this waiver program. We heard from someone last week that they had previously been denied, and they have people are going on to the studentaid.gov site and seeing that their loan balance is zeroed out. It's funny because the paperwork comes later, but the loan balance will actually be zeroed out on the platform online that you can see in advance. And so some folks are wondering, is that an error? You know, what's going on? Why don't I have the loans anymore? Because they haven't really gotten any explanation for that. So they are processing behind the scenes. It's just a matter of time till the paperwork has a chance to catch up. And in part, it's due to these servicer changes. We're not just having a servicer change with Fed loan, we're having servicer changes all over the place. There's new ones, some are getting out of the business like Navient. It's rather huge what they're doing.
Yeah, and that was actually my next question. What is Navient transitioning to?
I forget the name. It was Aid something, Aid Advantage. And so they shouldn't have any dealings with public service loan forgiveness. So for here, remember, all the loans are going to be going primarily to Mohila. So Mohila is probably going to be your new servicer if Fed loan was your old servicer. Navient shouldn't have anything to do with it, and the new Aid Advantage that Navient loans are going to shouldn't have anything to do with public service.
Okay. Do FFEL loans after consolidation into direct loans have to be an income forgiven repayment plan?
Yes. Going forward, when you do the consolidation, you have to sign up for an income-driven plan. Number one, it's required when you do a consolidation for a 3-month period, you have to be in an income-driven plan. But even after that, to get credit for public service loan forgiveness, they're allowing the waiver to fix the problem, to give you a second chance to fix what had gone wrong, but they're expecting that you do it right from here on out. So you have to be in an income-driven plan. It can be any one, but it has to be. And those are usually, like I mentioned, pay or repay, ICR, which is not quite as good, IBR. There's also IBR for new borrowers, but we don't really often see that because it has to be only those with loans that are more recent, and we usually don't have that. And then ISR. If anyone out there has ISR, give me a call. We need to talk right away because ISRs do not have forgiveness, and you need to change into the other plans and make sure that's done correctly. There's hardly anyone out there with those anymore. Probably you're going to have been in extended or graduated, and you need to get out of that. You need to go in income driven.
For those who don't know, what does ISR stand for?
Income sensitive. It was the first program out there that allowed for a lower payment based on someone's income, but it didn't have any forgiveness. The whole purpose of being an income-driven plan is to have a lower payment based on your income, 10 or 15% of your discretionary earnings, and also have forgiveness at the end. The alternative is you just put your loans in forbearance or deferment. The problem with that is that the loan balance snowballs. It gets bigger and bigger. Interest capitalizes. There's no interest subsidy like there is in the income-driven plans, and there's no plan forgiveness. So you just basically shot yourself in the foot by going into forbearance all this time because you're not getting credit towards anything, and your loan balance is getting bigger. Also, if you try to buy a home, they'll usually use 1% of the loan balance to determine what your student loan payment should be instead of the income-driven plan, which would be lower. For instance, if you have $300,000 of loans, which as lawyers, that's more common than not, that would assume that you make a $3,000 payment on your student loans every month. Well, if you're working public service, your payment might be $200. So yeah, so go in the income driven, tell your mortgage underwriter, give them the documentation to show you're an income driven. They will use that installment payment at $200, and you'll then qualify for a mortgage loan. So you've got to get out of forbearance. Forbearance is a temporary fix at best. We do use them for some situations, but we don't use them long term for most cases. It's just kicking the can down the road.
Right. How often do you recommend certifying or recertifying your employer?
I recommend every year. Unlike income, you have to, it's mandatory that you certify your income every year. I recommend that for employment, you also do so every year. And think of it this way. Even if you have the correct loan type going forward, your employer might make changes. You might be working for a subsidiary where you don't even realize it. The primary purpose of business might have changed. The forms may have changed. So if you send it in every year, you won't be blindsided 5 years later with a problem that wipes out 5 years. There was a lawsuit brought by the ABA, a group of attorneys who had received letters that stated that they were entitled to public service loan forgiveness. And then all of a sudden they received a letter saying, nope, you're not. We changed the forms. And they all got together, and I understand there was a lawsuit filed, and I believe there was a summary judgment hearing where the judge indicated that the Department of Ed, could not arbitrarily and capriciously change the form in that manner. But I bet everyone that did that, had they not filled out that paperwork each year, they wouldn't have known of that problem coming. And here they had an opportunity to fix it while they were still in their 10 years. Otherwise, they may never have known to fix it, or they would have been fixing it after the 10 years, still working there because they're still getting it fixed. Yeah. So if there is a problem, you want to know about it early and you want to have time to fix it.
Perfect. Well, it looks like we have 1 minute left, so we're about to run out of time. So thank you so much, Christie, and thank you to our listeners for tuning in today. And from the Florida Bar YLD, we hope that you have a happy holiday. So
thank you, Sarah. Hope everyone has a great week, and get out there and get rid of your student loans.
Absolutely. Thank you.
Bye-bye.